One of the questions we get from time to time is, why should I try to avoid the probate process in Georgia? Or it may be phrased along the lines of whether I should structure my estate plan to avoid the probate process in Georgia. Those are good questions. I'm attorney Joel Beck, estate planning and probate attorney with Peach State Wills and Trust in Lawrenceville, Georgia, and I'll answer those questions in today's video. So the question we get from time to time is, why should I try to avoid the probate process in Georgia, or should I try to avoid the probate process in Georgia? The answer really is, well, it depends on your particular wishes and goals and your situation, and it may really depend as well on how your assets are owned. But to try to dive deeper into that question, it's helpful to understand what the probate process is, because I think a lot of people have a misunderstanding about that. So in Georgia, probate is simply the process that's used to transfer your assets from your estate after you die to your loved ones after your bills are paid. Now, the probate process in court is a court-overseen process. A probate court in the county where the decedent lived when they died is going to be the county to administer that probate case. Each Georgia county, all 159 of them, have a probate court. And the probate process is essentially uniform across the state, using the same forms and the same probate court rules and, of course, the same state laws. In a nutshell, once somebody dies, if they have a will, then somebody is going to file to be appointed as the executor. They're going to fill out the petition to probate the will, file that with the court, and wait on that to be approved by the judge. Once the executor is appointed, a notice to debtors and creditors is run in the county's legal newspaper, and the executor is going to wait. He or she is going to marshal together the assets of the decedent and then wait for the notice period to run so that he or she can determine what are the valid bills of the decedent, and we're going to pay those first and then distribute anything left over in accordance with the will. Now, this process is not quick, it's not immediate. Some people are going to say it's slow. A fast probate case may take 6 months. A slow one may be going on for a year and a half or so. And all of this is without anyone coming in and contesting the will in probate or contesting who should be appointed as the executor or the administrator. Generally, we find that more rural areas of the state are going to move things along faster than the more populated counties, such as those here in Metro Atlanta. The busier the court is, the busier the population in the county it serves. Generally, the slower that process may be. In other words, if you live in a more populated county, such as anywhere in Metro Atlanta, the time delays associated with probate are more significant, I think, than if you live in a rural area. Now, unless our courts increase judges and staff and funding, I really don't anticipate that the process there is going to become any faster anytime soon. Now, probate is a public process, meaning that the documents that are filed are generally publicly available to those that want to go to the court clerks and pull the file and look at it. For some people, that's a concern. For other people, that's not. Now, let's turn to the question of, why should I avoid probate, or is that a good thing for me? There's a few reasons that some people will use to suggest we don't need to go through probate. We ought to try to avoid that process, and these reasons may or may not apply to you. First, avoiding probate eliminates the time delays associated with the probate process. That makes sense. If we don't have to go through the process, then the length of time, the delays in that process aren't going to apply to us. As I shared earlier, a basic case is generally going to take about 6 months minimum. So if you want to avoid that delay, be able to have your bills paid faster and have your relatives, your loved ones, get their hands on your assets and be able to use them as appropriate and needed, avoiding probate and the delays associated with that may very well be something you should do, and using a revocable trust plan designed to avoid probate may be very wise. Second, avoiding probate keeps your affairs private. As I mentioned, probate is typically a public process, and your documents filed with the court are generally public. You can keep your affairs private and keep snoops and nosy people out of the file by simply not having a file and avoiding that process. Third, if you want to lessen the likelihood of challenges to your estate administration, avoiding the probate process is smart. While trust can be challenged, that's a harder challenge to bring, and generally speaking, the longer you've operated with a trust, the harder that challenge would be to overturn your trust in your detailed estate planning. Finally, avoiding probate avoids the cost associated with that process, but that's really not that big a deal here in Georgia. The cost for a probate court cost in Georgia are typically only a few $100s, including publication cost and fees to get extra certified copies. In fact, you're going to pay more than those costs in a will plan if you do a revocable trust plan. But of course, you're going to save the probate fees, you're going to save the delays associated with probate, and keep things private. Now, if none of these factors appeal to you, then there simply may not be a reason or a concern that you should avoid the probate process. Nothing is wrong with probate. It is a process that works. Wills, by their very nature, go through the probate process and are administered routinely through this system in Georgia. But we did talk about what that process looks like and how the time may take. If you want to avoid that process then, for any or all of those reasons we discussed, then using an estate plan that's designed and implemented in a way to avoid probate is going to be the route that you're going to take. That's probably going to mean using a revocable living trust plan and fully funding it and operating it as you should. Now, for more information on revocable trust or wills or other estate planning documents, check out our other YouTube videos and be sure to look at our website and blogs at peachstatewills.com. And to download our free guide to estate planning in Georgia, just go to peachstatewills.com, click on free info at the top, and then select estate planning resources. There you can learn all about the differences between will plans and trust plans and get answers to a lot of the frequently asked questions that people have about their estate planning. Then, when you're ready to speak with an experienced estate planning attorney, we'd be honored if you give us a call. You can reach us at 678-344-5342. Thanks.